Hey guys, good morning. This is Bold Patents Law Firm. We're doing our weekly broadcast. I'm JD Houvener, your host here this week. We're going to have our co-host Matt Kulseth on and hopefully a special guest as well, Vivek, out of the Jayaram, I hope I'm saying that right, Jayaram law firm. And they do business law. And it's been great having a few guests on the past few weeks. So I thought, hey, why not bring on Vivek? I send him referrals. He sends me referrals too. And we help our respective clients out. So he's going to come talk about starting up, setting up your business, getting serious about operating agreements. We'll be talking about IP as well on the patent side and on the trademark side too. So this is a live broadcast. It is a public broadcast, so please do not share any confidential information. And this is not an attorney consultation by any means. So please just consider this a cursory, process level, high level view. The information we're sharing is about the law. But if you have any specific questions about your case, you'll need to contact us directly. And you can do that on our website at boldip.com. All right, cool. Let's see. We got one guest popping in. Matt Kulseth is here. Matt, good morning. Let's bring you on, sir. And I'm on the phone. Let's add you to the stream. Matt, good morning.
Hey, morning. How's it going?
Going good. This is actually working pretty well. I got you a 2-bar 5G. My wife is driving. So good to have you, man. So hopefully Vivek can join. We've been trying to get him on. He's got a powerhouse business law firm, and right there on the front page of their website, they help innovators form, start, and grow companies. So I'm excited to see if he can pop in a little bit later. And so Matt, here we are, sir. We had the planning, to talk about, starting up in biz. We're here every week. Maybe I'll let you if you have anything you wanted to talk about, maybe things we've brushed over, but we haven't really drilled down. Any topics you think are burning questions that a lot of your clients ask you and we haven't brought up yet on the show?
Yeah, no, I mean, there's certainly a number of topics we can discuss. I would
put it in the spot here.
No, that's fine. So I was just talking with Sheila, one of our paralegals, and discussing a little bit about the goals of 2022 for the trademark side of the business and where we hope to take things. I think it's a great opportunity right now for clients to start thinking about what their goals are, not just financial and growth goals, but also what are your IP goals, right? What's the goal of the business in the next 5 years? So anyways, planning is an important thing to be considering right now, in Q1 of 2022. In terms of some of the topics that I think are just like gold mines for clients to discuss, I would say that we could have a conversation around Amazon, quite frankly, and what that looks like from an IP perspective and specifically a trademark perspective, because it's a question that I get all the time. So if you don't mind, I'll kind of talk a little bit about Amazon and their brand registry and the benefit of having a trademark registration.
Absolutely. I'll try to make you the kind of center stage here on the view. Let's see if I can do that. But go ahead and get into it, Matt, and I'll let you know if I see any comments. But you go ahead.
So obviously, in the last decade, we've seen a huge rise in direct-to-consumer sales, right? So we have a lot more clients who are selling products on Amazon, Etsy, eBay, through their own Shopify websites, that sort of thing. About 6 years ago, Amazon came out with what they call their Amazon brand registry, which allows federal trademark holders, specifically those with registered trademarks, to apply to be part of Amazon's brand registry and have enforcement rights on Amazon. For the longest time, if you were a vendor on Amazon, you had very limited rights in terms of enforcement of your federally registered trademark. The process was tedious. It required typically a lawyer to handle, and the results were not expedient or good for a lot of my clients. Enter the Amazon brand registry, and now enforcement for a registered trademark holder is much more simple. And there are some serious benefits to being an Amazon brand registered holder today. One of the big benefits that a lot of clients are interested in if they're selling products on Amazon are access to what are called A+ pages. And you can think of A+ pages as a landing page or homepage on Amazon So if you were to go to, say a fairly sophisticated brand with multiple products on Amazon, more likely than not, they're going to have a really nicely designed like homepage on Amazon. It's going to tell their story. There might be videos and pictures. It's going to be a more curated experience other than just your typical Amazon website or Amazon items page. And those are called A+ pages, and the only way you get access to those as a vendor on Amazon is if you have a registered trademark, and registered with the United States Patent and Trademark Office or another country that you're operating in. But you need to be registered with the USPTO in order to participate in that program. Beyond just having a beautiful kind of homepage on Amazon, I mean, there's some other benefits too. I mentioned enforcement. It makes it much easier to enforce your trademark. Beyond that, if you are a registered brand owner on Amazon, you also have access to more sophisticated marketing tools. I mentioned videos. You're able to post videos on your brand page, as well as there's other marketing opportunities that are only available to registered brand owners on Amazon. So that is a question I get a lot from clients, is that, I'm new to Amazon. I really want these A+ pages. I'm told that I need a trademark registration. Can you help me? And the answer is yes. We certainly can help you. And it's been a huge impetus for our business the last 5-6 years, is working with clients who understand the benefit to having a brand registered with Amazon and needing that support to get it registered with USPTO. Now, the downside is that the USPTO process is relatively slow, right? Especially with COVID, timelines are pushed back almost double what they used to be, pre-2019. So the process itself is pretty slow. So if we can get clients thinking about trademark brand registration, 6 months at least before they go to market and open that store on Amazon, that'll definitely expedite the process of registering with Amazon ultimately. So that's a little bit about the brand registry, the benefit of being brand registered with Amazon. It's going to continue to be a growing part of our business moving forward. But yeah,
Hey, I got a couple questions on that. So, I mean, if I'm starting out, did you have to pay for this? Access to get this A+ page? Talk to me about like kind of the timeline. If I apply for a trademark submit a trademark application, say through Bold Patents, would I be able to get that registration process started, or do I have to wait until it's actually registered at the trademark office?
Yeah, really good question. And that's been kind of a moving target the last couple of years. It used to be that you could only apply for Amazon's brand registry if you were registered with the United States Patent and Trademark Office on the principal register. And I can talk about that in a second as well. Today, it's a little bit different. Volunteer firefighter in the Patriots one. It's a little bit different today in the sense that if you have an application at the USPTO, you can apply to be part of Amazon's brand registry and have some pre-approval, but they're not going to allow you to unlock the full suite of tools with Amazon A+ pages until you get that registration. So an application is better than nothing in the sense that it will help kind of expedite the process once you do register, but there's no substitute for registration.
Got it. And will they do kind of, do you have to go, or do you have a, yeah, by the way, I should do a quick little, Matt is Superman, by the way. He does have a bat phone, and he gets called out for fire duty. Was that a serious call? Do you have to take that?
No. I mean, it's serious, but there's a lot of volunteer firefighters in my community, so I'm good.
Thank you for your service there. Okay, back to it. So I'm going to play a little bit dumber because I actually probably am. On this, so with the application, you submit for it now. Now, when you get all the way to the point where you have the page up and you say that Amazon will help with enforcement, is it something that an individual business owner can actually rely on, or should they still probably get the advice of a trademark attorney to help them with enforcement should something come up?
Good question. So the form itself, let's just say like you have a product on Amazon, you are brand registered, you are good to go. Yes, you can enforce it yourself fairly easily. However, the caveat being that I always recommend, talking, if you're a client to the firm, just call me, just email me before you do anything like that. Because I want to verify ultimately that your registered trademark rights are better than maybe somebody who's unregistered, right? There's always the possibility, if we don't do a full search and opinion, that somebody was using that similar named brand for similar products or services before you and just never registered. So before we, go kick that hornet's nest and end up in, some, trouble, I want to verify that we actually do indeed have better registration rights than their first use rights. So that's a really good point. So I always recommend just,
Yep.
give me a call.
And as the business owner, you're always like, oh, you think you're in the right. And before you go, step in it and go claim, some sort of, allegation, you want to make sure that you actually do have your own ducks in a row. So that's a great point.
Yeah, good question.
I mean, I know, go ahead. Yeah.
Go ahead.
I was gonna say, on Amazon, I've never sold products on Amazon, so I am truly in the dark a little bit. But let's just take it simplest case. It's products. When you sell on Amazon, is it true? I should start. Is it true you can actually sell to individuals out of the country? And if so, can you talk a little bit about international sales and trademark rights and how that works a little bit?
Yeah. So let's just take like the example of an American vendor on Amazon. It is relatively easy as an American vendor to sell into both Canada and Mexico from the distribution network here in the United States. So that's pretty common that you will see a lot of our clients sell in USA, Canada, and Mexico. And that's just from pure convenience standpoint. Now, our clients typically aren't registered, in the respective IP agencies in Canada or Mexico, but they don't necessarily need to be in order to sell there. Now, their enforcement rights are going to be limited, right? They're not going to be able to enforce their trademark in Mexico or Canada without a registration in that country and brand registered in Mexico or Canada. But I think for 99.9% of our clients, registration in the United States is kind of the be all end all. That's where clients are really making their money. That's where the IP protection is most important. The United States obviously is very strong on IP and enforcement and protection, and you're just not going to get that in a place like Mexico or, a lot of places outside of the continental North America.
Cool. So yeah, just kind of the law school exam question type thing.
Yeah.
I got a company. We make soda. The name of our soda is Freshy Soda, and we've got a trademark registered for Freshy. Okay, and we have a nice little design and a word mark.
Yep.
We're awesome. We're crushing it. We've combined with a cool company to make an apparatus. It's the first type of apparatus for the top. It comes out and it never sprays you down, no matter how much you shake it up. Okay, and so it's a patented trademark. It's awesome. Spent a lot of money on it. Here comes Freshy out of Canada, right? Launched this very similar product. It looks a little different, but it's obviously a trademark infringement. It seems like it, and they're selling on Amazon. What would you think? What are your first thoughts? How would you approach that? This other Freshy 2 out of Canada.
Yep. So if they're selling their product from Canada in the United States, it's a direct violation of your United States trademark registration. That's a no-brainer. If they're selling exclusively in Canada and not doing any marketing in the United States, then we got a bigger problem, right? So at that point, that's when we would say, hey, we got to take our registration from the United States. We got to port it over to Canada using the Madrid Protocol or filing a fresh application in Canada. And that's where historically, in the past, we've basically hooked clients up with Canadian counsel and had them basically take it from there. We're obviously licensed here in the United States. That's our expertise. We have a network of great attorneys all around the world that we can rely upon to help our clients. But at that point, we have to get Canadian counsel involved. They'd probably send a cease and desist. They'd apply for a trademark registration in Canada because I'm sure there's going to be some crossover in terms of our products in Canada at that point. But that's kind of the worst case scenario, which, this doesn't really apply to our clients, JD, but if you look at some of these global, products, Coca-Cola, Nike. I mean, they're registered in every country in the world, which is insanely expensive. But they have to be, because if they're not, they're going to be, playing whack-a-mole with companies who are just basically registering their brands in all these countries. So that's a whole other type of attorney law firm, but it certainly is a problem for some of these larger multinational companies.
Awesome. Thanks for taking my wild questions, going deep. Let's take a little zoom out again. Kind of those FAQs, if you will, things that maybe you have a couple more in your head. Common questions that that come up as an entrepreneur who is securing trademark rights for the first time, perhaps, and also trying to think about their company. What maybe sort of crossover between trademark and business law. What are some areas that you think would be nice to sort of lay out some answers for people?
Yeah, a common question that we see. Let's just take the scenario where a client comes to us with a cease and desist. There's multiple reasons that a client's going to get in touch with us. One could be, they're aware that they need a trademark registration and they want to work with a competent firm who knows what they're doing and is a specialist in this. The other is that they get a cease and desist, right? And they need to deal with it. One of the common questions that I see is about, I received a cease and desist, and there's something about a supplemental trademark registration. So the question would be, what's the difference between a principal trademark registration and a supplemental registration? And those are really important distinctions. And a lot of attorneys who don't practice trademark law aren't going to know. So most clients aren't going to know either. So there are two databases at the USPTO. There's the principal and there is the supplemental database. The principal database means that if you're registered on the principal register, you have enforcement rights, and that trademark registration can be taken to federal district court and enforced. It also means that places like Amazon, Etsy, Facebook, Instagram will all recognize that registration is valid and enforceable, and they will have their own internal processes to enforce that trademark if you so wish. It's different than the supplemental registration, which basically means that you have a registration that may at some point be entitled to protection and registration on the principal database. But a supplemental doesn't get you the enforcement rights that a principal registration does. However, a supplemental registration will still allow a client to use the registry trademark symbol, the circle with the R inside of it. So oftentimes I will see clients receive cease and desist from third-party counsel, from another individual, and they will cite their supplemental registration as proof that they have a trademark registration that they can enforce. And that's just not the case. A supplemental registration is not worth anything. All it means is that you may, at some point down the road, be entitled to registration of that typically descriptive trademark. Typically, a supplemental registration can mature into a principal registration if, after 5 years of continuous and exclusive use, that brand has acquired what's called secondary meaning, which is when the consuming public basically comes to recognize that brand is the source of a product or service. So there's kind of a whole bunch of things that have to go into taking a supplemental registration to the principal.
Got it. So back to my soda. Well, similar. I like using similar analogies. So fizzy soda, right? That's going to be a descriptor, right? It's describing kind of the soda. Poppy pop. Okay, they're going to sit on the supplemental, right, until they can demonstrate that that people know them, right? Affiliate that name with their specific brand. I mean, is that how they might get off of supplemental?
Yeah. So fizzy would probably be like, a good trademark. Poppy, I mean, it sounds a lot like pop, right? Let's just say like Poppy is a supplemental registration.
Okay.
We would obviously file and make the argument that it should be on the principal, but if the USPTO pushes back and if it's between something or nothing, we're going to go with something, right? And that means that we'll be on the supplemental registration database. 5 years later, if that client is just kicking butt and continuing to grow their brand awareness, at that point, when it's time to renew that trademark, we'll have the conversation with the client about refiling the trademark for the principal register, basically claiming acquired distinctiveness. And we'll basically say that, hey, this trademark is somewhat descriptive, but look at the sales, look at the advertising, look at the reviews we've gotten, the articles that have been written about this brand. The relevant consuming public has now known Poppy to be this soda brand, and as such, we are entitled to registration and enforcement.
Got it. But meanwhile, while they're earning all that reputation, they wouldn't have the ability to enforce a cease and desist like you're talking about in that example you mentioned earlier. They might be able to send a letter, but if someone's not looking carefully, someone might get the idea that they actually do have registration for Poppy when they don't.
Correct. Yep. So yeah, we would still potentially send a cease and desist, with the caveat that we know that our enforcement rights are limited. Clients can still potentially rely on common law, which might be like a state level action if necessary to enforce it. But our enforcement mechanisms, the levers that we pull, are fairly limited.
Got it.
Yeah.
Cool. Right on. Well, no live questions. We had Mankour and Muad say thanks. So you're welcome, Mankour. Keep any questions coming or any topics you want to hear about. Maybe just one more live on the spot kind of question. So let's say, I'm just trying to come up with interesting questions here, Matt. But let's say in a business context where you've got one company acquiring another, okay, and sort of when trademarks come into play. Let's say, trying to stick with the same examples, but okay, Poppy does grow. Poppy's big, and they finally get their principal registration. And the next year, they're looking to acquire another soda company, Zoomer Soda. If they wanted to, and Zoomer did okay, right? That's the reason why they're buying it. They kind of want to keep it as a different brand. It's a little edgier. I don't know, maybe I got a little more sugar content, maybe a little caffeine, kind of a, Zoomer, right? So, but they want to keep Poppy kind of this straightforward, simple, everyday soda. They want to keep both brands under the same company. Things to think about.
Yeah, I think the first thing to think about would be if you're going to, have a portfolio of trademarks under one company. That's all well and good. But when you acquire another company that has trademark registrations, it's important not just to acquire that company, but potentially transfer the IP as well. That's something that gets overlooked. I see a lot, I think, in buy-sell agreements between companies, is what actually happens to the intellectual property registered at the USPTO. So when you acquire, let's just say, for example, Poppy or Fizzy decides to, Poppy decides to,
Poppy. Yeah.
Poppy decides to register or acquire Fizzy's trademark registrations, right?
Okay.
And they're going to basically dissolve the company, but take the IP in-house, right? So they need to transfer that IP. Well, they need to assign those trademarks to Poppy. And they need to do that with a trademark assignment. So as part of the buy-sell agreement, both parties would sign an assignment of trademark rights agreement, which would be the official document that we would provide to the USPTO, notarized by both parties, that the trademark registrations of the one entity are now the others. Fairly simple to do, but I see it missed all the time in our practice. Well, not our practice, but I see in our research, I see it being missed by other attorneys all the time. That needs to be done. If you don't assign the trademark rights from the one company to the other, and that one company goes out of business, there's a good argument that you've abandoned those trademark rights.
Got it.
So assignments are huge. They're easy to do. If you're not acquiring the company itself, then those trademark rights need to be assigned before you dissolve the company.
Okay, cool. I like that a lot. Great advice, Matt. Excellent. Yeah. I think we covered a lot. Supplemental versus principal. We covered how to get something on Amazon and listing page. And then we went into international stuff. We're all over. So good subjects. Too bad we couldn't get Vivek to join this week. We'll try to catch him on a later session. But Matt, again, bulletproof on your answers. Thank you for that and being on the spot too. I appreciate you joining me again. So we'll see you.
It's always good
We'll have
seeing
you on next. Of course, we'll have you on next week. Thank you for those live viewers out there. If you're watching after the fact and you want to stick in a topic, you had a question, anything about patent law, trademark law, we'd love to hear it. You're the reason why we're here, right? We want to have your input. So we'll see you next week at 9 o'clock Pacific time. Take care, buddy. Go big, go bold.
See ya.